Yeah, thank you. I will, as I already mentioned, I will practically continue where Eva's presentation ended, or at least take up some of the points. But in contrast to Eva's presentation, I will rather focus on what can be done in the field of animal law with the legal tools that we already have. And at the office of the Animal Protection Commissioner in Berlin, we are often approached by people who are asking whom they could sue for causing harm to animals, or if it wasn't possible to abolish factory farming by suing someone. And apparently there is a certain understanding in the public that each and every problem can be solved through a lawsuit, even in a civil law jurisdiction where legislation and adjudication are strictly separate. Maybe people have watched too many American courtroom dramas, but anyway, in recent years, the use of lawsuits as a strategy to stimulate legal and social change has gained more and more attention also in the civil law world. Therefore, I would like to explore the potential of strategic litigation for improving the situation of animals and thereby shaping animal law also as a legal discipline. As the title suggests, my presentation will take the perspective of civil law jurisdictions, but I will also focus on civil law in the other sense of the term, civil law as private law, regulating conflicts. Yeah, it's on purpose. Civil law is private law, regulating conflicts between private individuals. The main characteristic of strategic litigation is that it pursues a variety of goals, which comprise goals within the legal system, but also extra-legal goals, such as attracting publicity, promoting a social movement, or exerting social or economic pressure. With regard to litigating animal law, we may distinguish four legal goals. First, the private enforcement of already existing standards of animal welfare. Second, including certain legislative improvements of these standards. Third, shaping the legal discourse on animal law and animals in general. And fourth, causing maybe a system change towards at least a drastic reduction of animal suffering. It is of utmost importance to clearly define which of these goals should be pursued by the litigation, since the choice of the right strategy crucially depends on the goals to be achieved. Of course, different goals can be mixed, and I have only categorized them vaguely, while they would have to be specified as precisely as possible in a particular case. Once the definition of goals is settled, an overall strategy has to be chosen from the arsenal of available strategies. Now, what are the procedural weapons from which we may choose in an animal law case? In the following parts of my presentation, I will try to systemize conceivable approaches and to illustrate them with the scenarios of concrete animal law cases. As a starting point, we can distinguish between direct and indirect strategies. With a direct strategy, I mean a strategy where someone directly invokes the interest of an animal, be it in the form of animal rights or in the form of obligations towards the animal. The simplest type of a direct strategy lies in the filing of a criminal or administrative complaint with the authorities by which they are notified of conduct violating animal protection statutes. The complainant usually, as we've already heard, does not have the right to actively participate in the further proceedings. However, such a complaint can have strategic implications, as is shown by an example from Germany, where in 2013, PETA filed a criminal complaint against the practice of shredding male chicks. Although the prosecution dismissed the complaint for other reasons, it established that the practice was illegal. In response to this finding, the competent ministry ordered its agencies to impose bans on the breeding factories, whose owners in turn filed suit against the administrative ban, going through all the courts until the Federal Administrative Court, as you may know, confirmed the illegality, but referred its implementation to the legislator, who then in 2021 finally inserted a new provision in the German Animal Welfare Act, explicitly prohibiting the shredding. This whole chain of legal discourse was put in motion by the initial complaint, which turned out to be a strategy inducing legislative improvements. Supposedly, this exact sequence of events was not planned, but it can be explained and examined as an example of strategic potential. A direct strategy with more influence on the further proceeding would be the filing of a suit in the name of an animal. Roughly, this is the strategy used by the Non-Human Rights Project in the US in their habeas corpus petitions, invoking an animal's right to bodily liberty. Although in civil law jurisdictions similar rules and proceedings are available, it is totally unrealistic that a judge would ever apply these rules to an animal against the clear legislative intent, which is confined to humans. A more powerful direct strategy may be found in collective actions instituted by animal rights associations in the interest of animals. As we've heard in the last talk, such actions are possible in France and also in some states of Germany, but they still face considerable difficulties. As it was already raised by Visa, the problem is that the associations do not have the necessary access to information. They have to fight for every bit of information that they need. And also the procedural options are quite limited. All of the strategies mentioned so far are directed against the state as the opposing party and would require the state to take action for the benefit of an animal in a particular case. As another type of direct strategy, actions against private individuals could be conceived. For instance, can I sue my neighbors for maltreating their dog on behalf of said dog? Or a company known to violate animal welfare law? Again, at least in civil law jurisdictions, such a suit would be placed too far outside the statutory framework to have any serious prospect of success and could only be of rather symbolic value. So this is where indirect strategies enter the scene. Indirect strategies do not rely on rights or welfare or any interests of animals, at least not on their surface, but on human interests the legal systems are accustomed to. The point is now that we choose specific human interests whose protection at the same time benefits the interests of animals, as a side effect, so to say. Such indirect strategies thus derive legal protection for animals from established legal mechanisms for the protection of human interests. You may call such indirect strategies anthropocentric or the wrong means to an otherwise desirable end, but this should not exclude them from our strategic brainstorming. So what are the suitable human interests that can kind of piggyback animal interests? We can classify them according to certain legal fields dealing with their protection. Here I have listed 6 promising fields, and you will notice that most of these fields rather concern the relationship between private parties than towards the state. so that litigation is mainly directed against private parties. In property law, to start with, and supplemented by tort law, cases could be built around the ownership interests in an animal that result from its legal status as an ownable object. If you are the owner of an animal, the law enables you to protect the animal against harmful influence from others by suing for an injunction, restraining the opponent from the harmful conduct, or for damages after the harm is done. On the other hand, if you're not the owner, but nevertheless care for the animal or otherwise act to its benefit, you may be entitled to compensation for your efforts, especially on the basis of negotiorum gestio, so agency without authority in private law, in the private law system. In this scenario, also the state may again come into play due to its responsibility for lost or abandoned property. In Germany, for example, every finder of lost property has a claim against the local authorities that they take care of the property, and the finder can enforce this claim before the courts. For instance, such a claim may apply to the ever-growing number of city pigeons who, as descendants of domestic pigeons, may still be the property of their original owner and thus be qualified as lost property. In tort law, another strategy could be based on the infliction of emotional distress to a human bystander of animal suffering. While most courts refuse to follow this line of argument, some courts in France and Italy indeed have awarded damages for emotional pain in such cases, and in Spain this is now expressly provided for in the civil code. As a prerequisite, however, there has to be a close relationship to the animal in question, and the discussion so far centers around companion animals. The next two channels for indirect strategies are sales law and labor law, which build on a contractual relationship between two parties, somehow affecting an animal. Being treated like things, animals can be sold in a sales contract, and the parties of this sales contract could, for instance, stipulate that the buyer of the animal is obliged to care for the animal in a particular way. In case of maltreatment, the seller could then sue for could then sue for performance of the obligation or for other contractual remedies, including, for example, a penalty promised in the contract. Another sales contract affecting animals is the sale of animal products, like meat or fur products. Arguably, such a product is not in conformity with the contract if it was manufactured in violation of animal welfare standards, since a buyer can reasonably expect that at least the statutory standards are met. An increasing moral awareness of consumers justifies the moral aspects of a product to contribute to its contractually required quality. In labor law, contracts affecting animals are the employment contracts of slaughterhouse workers, for example. Employers have special duties to maintain the welfare of their employees, including their mental welfare. The notoriously adverse conditions in slaughterhouses may thus give rise to claims for compensation. From a strategic point of view, however, employers typically are in a far more powerful position than employees, so that a group of employees or a trade union would be better equipped for such litigation. Further animal-related contracts not listed here explicitly are transport contracts, which may even be null and void if the agreed transport violates animal welfare provisions or the public policy, with the result that the customer of this contract is freed from its contractual obligations and may claim damages. However, the customer of a transport company will usually not have any incentive to challenge its business relation with the company due to concerns of animal welfare. Regarding the last two fields of indirect strategies, environmental law and climate law, I don't want to go into detail here and just give two hints for each. Through environmental law, the interests of wild animals can be invoked. Its advantage lies in the right of environmental associations to institute proceedings, which is based on European Union law and is therefore available in every member state. As to climate law, the vast endeavors and research in the field of climate litigation could be applied to litigation against states and companies from the agricultural sector, compelling them to reduce emissions by reducing the number of farmed animals. This strategy is currently tested in Italy and the UK. All of the indirect strategies that we have now examined involved human interests, which were linked to animal interests. But if we now go one step further, we can extend the chain and build strategies where human interests are linked to human interests that are linked to animal interests. As you will see, this is not as complicated as it sounds. We may call these strategies double indirect strategies, and the two main fields of application are competition law and corporate law. In competition law, a competitor is interested in maintaining equal competitive conditions towards customers, who on their part may have an interest in animal welfare. The main criterion for a violation of competition law is that the relevant conduct is related to the market in which the competitors participate. While the violation of animal welfare law by one competitor has so far been viewed as lacking the required degree of a relation to the market under German law, this is likely to change. A new law is about to be passed by the Parliament, introducing mandatory requirements for labeling certain meat products in order to inform consumers about the conditions under which the animals were kept. Such informational duties towards consumers are regularly viewed as market-related under German competition law, with the consequence that not only competitors, but also consumer organizations are able to sue for a cease and desist order, for damages, and most notably even for the surrender of profits. If a company does not comply with the standards warranted by its labeling. Then, lastly, in corporate law, a double indirect strategy results from the interest of investors in the value of their investment, which also may be affected by the judgment of customers interested in animal welfare. Therefore, shareholders can have an incentive to enforce animal welfare law by invoking their rights to information and to eventual damages against the corporation or against its board of directors. The direct, indirect, and double indirect strategies presented so far have all something in common, namely that litigation is initiated by the person seeking to protect animal interests. As a final extension of our strategic layout, we can add strategies that shift the burden of initiating a lawsuit to the opponent, be it the state or a private party. Such initiative shifting strategies potentially multiply the available options if combined with the other parameters. But only some of the combinations are viable, and I confine myself to the most important ones. The essential scenario here is the private rescue of an animal against the will of its owner, who, in response, may initiate litigation against the rescuer. Alternatively, the state may act as opponent and initiate criminal proceedings against the rescuer. Whether in private or criminal law, this litigation then revolves around the question whether the rescuer had the right to kind of privately enforce animal law or any other legal position from our indirect channels, especially from property law. In comparison to litigation initiated by the protector of animal interests, the chances of success here are higher if the private rescue can be justified by the lack of public enforcement in the face of an imminent threat. But not only rescue operations can shift the initiative for litigation to the opponent. Another shifting strategy is the disclosure of information on the opponent's responsibility for animal suffering. In response, the opponent could sue for infringement of privacy, confidentiality, or reputation, interests that would be weighed against the public interest in the information and also the animal interests. One last combination that deserves to be mentioned is another informational strategy indirectly enforced through labor law, namely whistleblowing, or to be more precise, making use of whistleblower protection in labor law, such as provisions against retaliation at the workplace and provisions for the establishment of reporting channels for the employees. In this context, it is noteworthy that the recent EU directive on whistleblower protection applies to whistleblowers who report breaches on animal health and welfare law, as it is laid down in the annex to the directive. However, this annex only lists the main EU legislation in the field while omitting the directives on minimum standards for particular species. So this concludes my brief sketch of litigation strategies in animal law. Coming back to the goals mentioned in the beginning, how do they relate to all the different strategies we have gathered? Well, it can be said that all strategies are suitable to enforce existing standards and to fuel the legal discourse on animal law. To instigate legislative improvements or even a system change, direct strategies are more suitable, but also have lower chances of success, with the initiative-shifting strategies still being more promising than self-initiated strategies. Generally, an important task of strategic litigation in civil law jurisdictions can be to build bridges, statutory bridges, so to say, over which a judge can walk without the concern of departing too far from the legislative provisions. Such bridges may be one way, though not the only way, that may lead into the territory of an autonomous field of animal law. Thank you.